The
Institute for Justice.
The National Law Firm for Liberty.
Welcome to the special edition of the Short Circuit podcast. I'm your host, Anya Bidwell, and with me today are four outstanding guests. IJ's President and General Counsel, Scott Bullock. Hi, Scott.
Hello.
And three IJ senior attorneys, Dick Comer. Hi, Dick.
Hi, Anya.
Wesley Haddad. Hey.
Hi.
And Bill Maurer. Hi, Bill.
Hi.
What do they all have in common? All four of them argued before the United States Supreme Court. Today on the podcast, they will tell us about their orator experiences and share some wisdom with those of you listening who one day will be making your own arguments before the court. I'm anxious to dive in, but first, let me briefly talk about IJ's U.S. Supreme Court practice. We have had 9 cases before the court, including the most recent one, Brownback v. King, a police accountability case, which will be argued next year. So far, we won all but one of the cases, Kelo v. City of New London. And Scott, I'll put you on the spot for that one. These victories have often been secured with broad coalitions of justices. Wesley here brought a unanimous victory in our civil forfeiture 8th Amendment incorporation case, Timms versus Indiana. And Michael Bindus's economic liberty case, Tennessee Wine and Spirits Retailers Association versus Thomas, garnered support of 7 justices. Michael is not here today, so I'll do all the bragging for him. We also prevailed in a campaign finance case, Arizona Free Enterprise Club's Freedom Club PAC versus Bennett. Bill is here to talk about that one. And we are still waiting on the Supreme Court to issue its opinion in Espinoza versus Montana Department of Revenue, our educational choice Blaine amendments case that Dick argued just several months ago. But let's start with Kelo. Scott, can you briefly tell us about the case?
Kelo was a case that arose in New London, Connecticut. And the city of New London and a private nonprofit called the New London Development Corporation wanted to take 15 parcels of land in an old working-class neighborhood called Fort Trumbull. And there were a group of property owners there led by Suzette Kelo who did not want to sell. And the takings were not for a traditional public use that eminent domain is authorized for, like a road or a public building or a reservoir or something like that. It was not even for the remediation of blight, which the Supreme Court had signed off on in the 1950s, and it first expanded the public use provision. New London's argument was simply that we're an economically struggling city, we need more tax revenue, we need more jobs, and that this new development promises to create more tax revenue and create more jobs. And even though that's not really within the definition of a public use, they relied upon the fact that the court had expanded the meaning of public use to include such things as public purposes and even public benefits. And the public would benefit from these takings, supposedly, in the form of more tax revenue and greater job creation. And so that was at the heart of the issue in the Kelo case. We had argued this case in the Connecticut trial court, where we got a mixed decision, partial victory, partial loss. Lost at the Connecticut Supreme Court in a 4-3 decision, and then petitioned to the U.S. Supreme Court, where in June of 2005, in a very divided Supreme Court opinion, the court, by 5-4 majority, upheld those takings and said that eminent domain can, in fact, be used for greater economic development.
Okay, now let's talk about Timms briefly. Wesley.
Well, Timms versus Indiana arose in May of 2013 when a young man named Tyson Timms was induced by a confidential informant to sell drugs to police officers. Tyson had a heroin addiction that he'd developed after being prescribed some opioids for a workplace injury. And having never been a drug dealer before, he was prompted by this confidential informant to sell drugs to police officers, and he drove his brand new Land Rover to that transaction. Police arrested him and seized his Land Rover. Now, Tyson was convicted of the crime of dealing and had no objection to that. In fact, he pleaded guilty to that crime. But he did object to the state's effort through a private law firm to attempt to forfeit his brand new Land Rover, arguing that forfeiture of that vehicle was excessive. He only incidentally used it to drive to the transaction. And the trial court agreed. The trial court in rural Grant County, Indiana, held that the Eighth Amendment's excessive fines clause prohibited forfeiture of that vehicle. Now, the case went up to the Intermediate Court of Appeals in Indiana, and they agreed as well, with only one dissent. The Indiana Supreme Court then decided that because the United States Supreme Court had not yet clearly held that the excessive fines clause applies to the states through the 14th Amendment, that it did not apply at all in Indiana. Now, this meant that not only was Tyson's forfeiture appropriate because the excessive fines clause didn't apply to state or local authorities, but indeed there were no protections against excessive economic sanctions for anyone in that state. To our surprise, two other states had agreed with that proposition, and so had the Michigan Court of Appeals. So we petitioned for cert, got cert in June of 2018, argued the case in November of 2018, and the court held unanimously that indeed the excessive fines clause of the Eighth Amendment applies to the states, just like nearly all of the Bill of Rights.
All right, and let's talk about Bennett now quickly. Bill.
Sure. Bennett concerned an initiative that was passed by the voters of the state of Arizona called the Clean Elections Initiative. And the idea essentially was that in order to get the so-called corrupting influence of money out of politics, they would essentially give people running for office a certain amount of money if they agreed to abide by spending limits and not collect or raise money themselves. This wasn't a mandatory system, so people opted in and decided to become publicly financed candidates, or they ran a traditional campaign. For traditional candidates, though, in order to keep them from speaking more than what the government wanted, every time a traditional candidate spoke above or spent money above the amount of money that was provided to publicly financed candidates, the government would cut a check to the publicly financed candidate. So for a privately financed candidate, the more they spoke, the more their opponents benefited. And it wasn't just one-on-one. It wasn't just I'm running against a publicly financed candidate. I spend more money than the government wants. They cut him or her a check. If you had multiple candidates who were all publicly financed in the case, every time you spoke above that certain amount, all of the publicly financed candidates would get a check from the government in that amount. So basically one instance of a person or a privately financed candidate spending more than the government wanted could result up to 3, 4, 5 times amount of money being distributed to their opponents. We represented both privately financed candidates and independent expenditure groups who basically said, look, this is a tremendous disincentive for us to speak as much as we like. And every time we speak, our opponents benefit, and that is interfering with our ability to freely express ourselves. We won at the trial court and then moved up to the Ninth Circuit, where we lost, which created a split with the 11th and a number of other circuits. So we petitioned for certiorari with the U.S. Supreme Court, and were granted it. And the argument was the first campaign finance law case after Citizens United, which was so it was a very closely watched, very contentious case. But we were able to prevail in the end 5-4.
Excellent. So now, last but not least, Dick Comer, take it away.
So our case, Espinoza versus Montana Department of Revenue, is still awaiting decision. We argued it on January 22nd, and I expect it won't come out until probably the end of June at the end of this current term. It clearly, from oral argument, looks like it'll be a very close decision. So around 2000, the Montana legislature started trying to pass a tax credit generated scholarship program for private schools. And in 2015, they finally passed it. We had been helping them all this time in trying to create such a program. But as usual, they created a bit of a monster of a program. Very small, but with all sorts of regulatory issues, which required the Department of Revenue to write regs. And in writing their regulations, the Department of Revenue, applying the state's Blaine Amendment, which was originally an anti-Catholic enactment, decided that the state constitution required that they exclude parents who select religious schools, religious private schools, from the program. We challenged that immediately in the trial court. We won, first a preliminary injunction and then a final injunction. The other side, the Department of Revenue, appealed to the Montana Supreme Court. And in April 2018, right before I retired, we argued out in Missoula, Montana. The argument went very well, and then in December 2018, after I retired, we lost in a 5-2 decision. That decision was, we requested cert from the U.S. Supreme Court, and, somewhat to our surprise, the Supreme Court granted it. So I came out of retirement and started preparing for the oral argument. And we are awaiting the outcome of that argument now. The issue is, does it violate the U.S. Constitution's Free Exercise Clause, Establishment of Religion Clause, and Equal Protection Clause to exclude the religious schools from the program? In Montana, as in every other state, the majority of the private schools are in fact religiously affiliated of some sort. And if you exclude the religious schools from the program, you severely truncate the value of a school choice program like that of Montana.
So, Dick, you mentioned that cert was granted to your surprise, right? And that's not surprising at all, since getting your cert granted is almost like winning a lottery, right? It happens so very rarely. So, question to all of you. How did you feel when you learned that your cert was granted? What was going through your mind?
Oh, I was delighted.
Oh, Dick. Yeah,
I was delighted. It was finally a chance to attack Blaine amendments at the U.S. Supreme Court. I mean, Blaine amendments have been in the background of a lot of school choice cases. 37 states have them in their constitutions, and about a third of those states, about 17, have interpreted their Blaine amendments very broadly. Although the Montana Supreme Court is the first Supreme Court to apply their Blaine Amendment to a tax credit-funded scholarship program. We won that issue already at the Supreme Court in a case called Wynn versus Arizona Christian School Tuitioning Organization.
So I guess you were all right coming out of retirement for this. You weren't too inconvenienced.
Oh, I was inconvenienced terribly, but I wanted to do it in the worst way.
All right, Scott, how about you? How did you feel when you learned that you're going up?
Well, it was phenomenal, of course, and it was one where the court called, and I think they still do this, is they call the counsel of record in the case and let them know. It was a few minutes before it had gone public, and at that time it wasn't quite as instantaneous now as it is now, when you kind of get this as soon as the orders list is put up online, and then everybody can see it. So I got the word. and I walked over to Dana Berliner, who she and I had been litigating not just the Kelo case together, but a whole range of these eminent domain abuse cases from Mississippi to my hometown of Pittsburgh to Westchester County to Ohio, all over the country. And we were hoping that one of these would pop and eventually get up to the Supreme Court, and that's exactly what had happened. So I walked into her office just completely unexpectedly. We didn't know the court was going to hand it down, and gave her a hug, and she looked at me like I'd kind of lost my mind, and then I kind of whispered to her the court granted cert in Kelo, and then was able to pull back and see what her reaction was, and I don't think I've ever seen a wider pair of eyes in my entire life.
So, Wesley, the day after you learned, you basically had to start preparing. What was your plan? How did you go about it?
Intensely. It was a tremendous opportunity for me to be the spokesperson for a big team of people that were working on the case. And the excitement on that team was a tremendous motivator for me to work very hard and ensure that what felt like an easy win came off indeed as an easy win. We workshopped every possible answer, every contingency, as though this were a case as closely fought as Kelo or Espinoza or Bill's case. And I think that ultimately it paid off. When you argue at the Supreme Court, you're playing on a national stage in a way that you're not in any other court. And it was very important to us as an institution. It was very important to me personally. It was very important to Tyson that everything come off without a hitch.
Bill, your case was kind of difficult to explain, right? So how did you think about the day after the cert was granted? What did you think about in terms of framing the case and kind of talking to the justices about it, as well as talking to the members of the public?
Well, our case was in kind of an unusual position, and it actually kind of goes back to your earlier question about how did you feel when we found out about cert being granted, because ours was a consolidated case. So there was another set of lawyers from the Goldwater Institute in the case. And so the U.S. Supreme Court frowns upon divided argument. And they went, and so we attempted to get divided argument so that both an advocate from Goldwater and I could argue the case, but the court denied it. And so it came down to a coin flip that we won, and we ended up arguing the entire case. So it wasn't
Next time
until
I go to Vegas, remind me to invite you.
Well, it wasn't until that coin flip that it really became real to me that I was going to be up there. I was going to be doing the argument that my grandkids would be able to open up the U.S. reports and see my name in it. And so that happened much later in the process than with everybody else. And so it was kind of, in some ways it was good because I didn't really have too much time to get nervous about anything. And I got, once that happened, it was like a boot camp, really. Constant preparation. I remember we instructed people if they saw me in the hallways to ask me questions, basically ask me an oral argument question. And so I just got, you begin to train yourself as to how to distill a rather complicated constitutional question into not only, I don't want to say sound bites because that doesn't convey the seriousness of what you're trying to do, but manageable amounts of information that answers the justice's questions in a way that also recognizes that you're not going to get a whole lot of time to talk and a whole lot of time to argue or say anything before you're going to get cut off. So it really was a training of how do I get this information to them in an understandable manner and as quickly as humanly possible. And that takes a lot of training, and it's extremely difficult. It takes a lot of hard work to make it seem like it's not a whole lot of work.
Right, because the oral argument actually sounds extremely conversational when you're talking back and forth with the justices.
It was very, and I think those are the most effective kinds of oral arguments, where you're actually having a conversation with the justices. They're trying to. There's a whole bunch of different things going on during the argument. The justices are talking to each other with their questions. They're trying to get you to either they're pitching you softballs so that you can address something that they want another justice to think about, or they're trying to get you to concede something. And so there's a great deal of things going on when you're having this conversation that you have to be mindful of the entire time. And I really enjoyed it. I loved it. It was one of the most fun I've ever had. So it was, I can't wait to do it again.
Scott.
Well, as you see, all the people who are talking here today, the focus is oftentimes on the people arguing, but when IJ gets a case before the court, it really is an all-hands-on-deck affair, and really everybody at the Institute contributes to the success of the argument, and everybody pitches in, and that includes, of course, not only the lawyers who are doing everything from rounding up amicus briefs, looking at research questions that have come up on potentially obscure parts of the law. Of course, our communications team is so active in getting this issue in the national spotlight. And then we have people here that are doing everything from making sure that people's relatives are in town for the argument to camping out overnight to make sure that we get the people we need into the courthouse for the argument. So it's really special to see how everybody rallies to make sure that we do everything we can to achieve victory.
And it sounds like quite an intense training, essentially, when you are doing moots, right? And trying to run through every different possibility, every different question that a justice might ask. So, Dick, how different was it training for the Montana Supreme Court argument versus the U.S. Supreme Court argument?
Very different. I mean, for the Montana Supreme Court argument, we had relatively limited knowledge about the justices of the Montana Supreme Court, but we were the winners below. At the U.S. Supreme Court, we were the losers below. So we were the petitioners at the U.S. Supreme Court. Preparing, I had the huge advantage of being able to talk to Scott, Wesley, and Bill and see how they had done it. And so basically the Espinoza team, of which I was merely the mouthpiece, followed the game plan or preparation that they had laid out over their cases. Obviously, we tried to emulate what Wesley and Bill had done more than what Scott had done because, we wanted to win in the worst way and still do, but you never know. But it was an extremely intense period, especially because I went from being retired to being grilled every day. I just censored myself. And we had constant moot courts, both internally and externally, involving lots and lots of IJ lawyers. And it was such good preparation that by the time the argument rolls around, you don't get any questions that you didn't anticipate at some point in a moot court or just in the question and answer sessions that you go through. So it was really good. And oral argument, like Bill, I really love oral argument because it's the only time that you actually get any feedback, any sense of what the justices care about. And that if you're well prepared, as we all were, you've got answers for their concerns.
Wesley, how was your travel schedule like when it comes to moots? I don't think people realize quite how many moots all across the country people actually do to prepare for this.
Yeah, well, in my case, as a first-time Supreme Court advocate, I wanted to do as many moots as possible. I enjoy them. I think that they're productive. I did 12 formal moots. 4 of them were outside of IJ. I did one here in Seattle at the University of Washington before doing moots at Harvard, Northwestern, and a week before the argument at the Georgetown Supreme Court Institute. And those were tremendously helpful because they allowed us to get outside of the kind of IJ silo and hear from people who may have a different perspective on the law or may have more experience with the court. And like Dick said, I think it resulted in virtually every question that I got being something that we had already practiced more than once in most occasions. The only thing that was an exception to that was Justice Breyer's kind of line of questioning, which I think kind of famously he will ask questions out of left field that can be very challenging for counsel. I remember Justice Ginsburg being kind of helpful in that respect and telling me what he was driving at, and that made it easier to address.
My question really is, are there cases where we have said that the punishment is disproportionate, where it's simply a question of the degree of punishment, i.e. life imprisonment, and the nature of the offense, e.g. stealing a golf club? And this is what I'm not sure there are. And if there are not, it seems odd, and I think I'd have to think about it, or maybe we should address in some way your argument as to why there is that difference.
Your Honor, I think if we posit that difference, yes.
Saying there is a difference.
Between sentencing a person for stealing a golf club to a life sentence. Mm-hmm. I think that, no, there is no difference, and that if there is that tension between the excessive fines clause and the cruel and unusual punishment clause, that in an appropriate case, this Court should resolve it.
I thought the 3 strikes, it wasn't simply stealing a golf club. It was the third offense. So it was a punishment for recidivists.
Absolutely, Your Honor. And thank you.
He also robbed a chicken coop.
We'll talk about oral arguments in a second. And one last question before we dive into that. Tell me how the hours before the argument went. How was it when you know that, within a very limited amount of time, you're going to go before the justices? What happened then? What was it like? Scott?
Well, needless to say, and I think this is probably true of all of us, you don't sleep very much the night before the argument. The important thing is you sleep the night 2 nights before the argument to make sure that you can do a day without a whole lot of sleep for it. But we were ready, and it really is. All the other folks here have mentioned it, but we think of every possible question that could be asked. You're constantly thinking about not only the questions, but also how you boil them down to their essence, too, because that's the one thing that every person who looks at the Supreme Court tells you have extremely limited periods of time to answer the questions. And so you have to say yes or no typically, and then maybe get out a sentence or two to explain your answer. But it's a real challenge to explain sometimes difficult and complex legal questions in a very, very simple and quick manner. But we were ready to go.
And tell me what happened on the way to the Supreme Court.
Oh, well.
In the car.
Yeah. So we were, I picked up Dana in a cab. And so she and I both live in D.C. And we were ready. And at that point, she had constantly been quizzing me along with everybody else. Bill said people stopping you in the hall and asking you questions about things. And this is just occurring randomly. So we weren't going to do that. And so both of us were, of course, keyed up. And Dana and I agree on a lot of things and litigated many, many cases together. And now she and I are running things at IJ. But the one thing we don't agree on very much is music. Dana being a product of the 1980s and not really liking some of the things that I'm into, like jazz and rhythm and blues and that sort of thing. So I knew I had to get her to sing something for me of something that she knew. So she gave me a little version of Eye of the Tiger right before we went. It stepped out of the cab and into the Supreme Court, and she did a pretty good job with it. She has a good voice, even if I had to listen to some more 80s dreck from her.
Did you get all pumped up after that?
I did. Surprisingly so.
Bill, I know you have a story to tell. Rather a macabre one.
Yeah, I had kind of an unusual morning before the argument. And in some ways it did take my mind off any nerves I might have had. While I was getting ready that morning for the argument, I reached into the one of the drawers at my hotel in the bathroom and somehow managed to run my finger across the blade of a razor and really cut myself very badly. And I was already in my suit, thankfully, but I was bleeding a lot. Tried to bandage it; it didn't work. Steve Simpson, who was a senior attorney at IJ, was there to pick me up and help me. And we were trying to wrap my hand up in paper towels. And, we finally got it to the point where I had this big ball of paper towels on my hand. And we started heading off to the court. I bled all over my phone, so I'm trying to text people about the arrangements. We get there, we go inside, and there's actually a lounge in the Supreme Court for people who are about to argue. And so I walked in, and the clerk of the court, the U.S. Supreme Court, at the time was a guy named William Souter. And he noticed this, just this gory mess at the end of my left hand, and he was like, "Do you want to go down to the nurse's office?" And I had no idea there was a nurse's office at the U.S. Supreme Court, but apparently there is. And I tried to, so I didn't want to interrupt. I didn't want to cause any problems, and I tried to say no, and he gave me some stories about some very famous advocates who had appeared before the Supreme Court with injuries, and how and basically did an excellent job of sort of manipulating me to go down to the nurse's office. And so I went down there. I was the nurse down there was a fantastic man. Very, kind of understood what was going on, and calmed me down about my finger. I wasn't really all that upset. I was just was more of an extreme inconvenience than anything else. But he bandaged me up so I didn't look like something from a crime scene photograph, and sent me back upstairs, where I learned that I had left my ticket to actually get into the court in the lounge. And the marshal stopped me and said, do you have your ticket? And I said, no. And he said, well, then you can't come in. And I said, but I'm the opening act. And eventually, Dana Berliner actually went back and found the ticket for me, brought it to me. I went in with, surprisingly large amount of time to spare. And by that time, I was thinking, nothing else that happens today is really going to be as sort of exciting and challenging as this. And so I was pretty calm by the time I sat down. I had everything all set up, and I was, it was just at that point I was just like, bring it on. I just want to argue.
I got the pleasure of reporting to the IJ team because I'd gone to the bathroom before the argument downstairs, and I happened to run into Bill, and Steve was there trying to re-administer this makeshift bandage that he had on his finger at the time, and they told me the story, and I got to report back to the rest of the IJ. I saw Bill, and how's he doing? He's bleeding. They're working on it and working to a solution. That's it.
Luckily, my sister-in-law is also a nurse, and that evening she was able to put me back together well. So I was appreciative that it wasn't a long-term injury.
And so that's kind of gets me to thinking about succession plans, as it were. Like, do you guys, when you're preparing for oral arguments, are you thinking about, okay, there's got to be, if in case something happens to me when I'm incapacitated for some reason, that I have a second chair who is going to be ready and able to step in and do this unbelievably important high-stakes argument? Wesley?
Well, in my case, there was nothing formally set up, but there was no question that my co-counsel, Sam Gedge, was equally capable of handling the argument. I think had something happened to me, he would have been able to step up and seamlessly do it. Sam was with me every step of the way at every moot, the source of a lot of my good answers. So I feel like had something happened to me, it would have been pretty seamless.
Very nice to have. Although it creates a perverse incentive a little bit, doesn't it?
Oh, right. Well,
if you are Sam Gedge, that is.
I suppose so. But, I trust that guy and my other colleagues with my life, I suppose.
Well, let's then talk about the actual substance of the oral arguments. Let's begin with Kelo, right? And Scott, you had quite an opening statement. Tell us about what you were doing there.
Well, one thing that we always do in Supreme Court arguments, and it gets back to this point of having to boil down your arguments to their essence, is you need to have a theme. You need to have the theme of the argument. This is true really for just about any argument, but it's especially important at the Supreme Court level, and something you're constantly trying to draw the court's attention back to. And so that's what you want to get out in your opening statement, because that's oftentimes about the only chance that you have to speak uninterrupted. Of course, that's changed now, as probably many of the listeners to the podcast know. The court is now letting advocates get 2 minutes, I think it is, to...
Yes, and we'll talk about that with Dick.
That's right, to talk uninterrupted. When Kelo was argued, that wasn't the case. So most you could get out 2, maybe 3 sentences before the barrage started, and that's what happened in Kelo. Even with a smaller Supreme Court at the time, we actually only had 7 justices on the court because Justice Rehnquist, who was still on the court at that time, was sick and getting treated for cancer, so he was not able to attend the arguments. And Justice Stevens had actually missed his plane back from Florida, where he was after their kind of winter break, so he wasn't able to attend. It was actually the first time in the Supreme Court's history that a female presided over the Supreme Court, and Justice O'Connor, who was the next most senior justice, was the presiding justice at that time. And so, but once we got out this opening statement, then we knew that the semicircular firing squad was going to commence, and that's what happened for the rest of the main argument in Kelo. And so the theme that we got out was the one that we wanted to keep returning to, which is if the court signs off on this use of eminent domain, what we call this abuse of eminent domain, this expansion of eminent domain, then really there's no limit on what governments can take in the name of economic development. And that was captured in the opening statement, and something that we return to again and again in the argument.
And then when the opposing counsel gets up there, right, and answers the justice's questions, there is this amazing hypothetical, and it's actually Justice Scalia and Justice O'Connor tag teaming, and then Justice O'Connor talking about Motel 6. So talk about that a little bit, and tell us what was going through your mind as you're sitting there and preparing for your rebuttal.
Yeah, I think that was really the key point in the entire argument. And it was something that rarely happens at an argument, but it did happen in Kelo, which is the other side essentially conceding the very theme of your argument. And this is what, we were hoping to make this impression on the justices, to leave them with it. Wow, what are the limits on this? And is there any limit on eminent domain power for economic development purposes? And so that's what I said in my opening statement about every church and corner store could produce more tax revenue for a big box retail store and the like. And then Justice Scalia and Justice O'Connor picked up on that and asked the Motel 6 question. Say if a community had a Motel 6 and they wanted more tax revenue, could they take it and give it to the Ritz-Carlton? That was the theme of our argument. And the opposing counsel for the city said, yes, Your Honor, that would be okay.
I just want to take property from people who are paying less taxes and give it to people who are paying more taxes. That'd be a public use, wouldn't it?
For example, Motel 6, and the city thinks, well, if we had a Ritz-Carlton, we'd have higher taxes. Now, is that okay?
Yes, Your Honor, that would be okay.
And at that point, I was like, my work here is done. That is what we wanted to get to convey to the court. They conceded it, and you could almost see, when you're that close to the Supreme Court, you really get to see their expressions. And so the look of shock on Justice O'Connor's face when he said that yes, that would be okay to do that. Was really apparent, and so that was exactly the theme we wanted to drive home. Of course, that statement about the Motel 6 made it into her very passionate dissent that she wrote in Kelo, and it was a point that I obviously had to hammer home in my remaining rebuttal time that I had at the end of the argument.
And that kind of goes to my question about rebuttals. So you're sitting there and you are thinking about, you probably have somewhat a prepared rebuttal, right? But you're also listening to the justices and thinking about, okay, what do I do? What do I address when I get up? So what were the things that you addressed in your rebuttal? That was obviously one of them. Yeah.
Yeah, so that was clearly one of. There's a few factual questions that you want to clear up in it, but that the theme and bringing it back to the theme that we addressed in the opening, and then what the opposing counsel had just conceded in his statement about it was something that we really wanted to drive home, and that's how we concluded the argument. So really thinking through and picking up on where the justices were in their thinking on this, and driving home your theme is key. This is also something that's really helpful for the second chair and the other folks at the table to do, because you're trying to decide what is the most important thing, and having that kind of almost instant powwows that people do is really essential for making sure you hit all the right points in the remaining time that you have. And what's interesting too is that what happened in Kelo, and I've seen this in other arguments, is that the court kind of exhausts itself oftentimes during the argument. And as I said, it was a nonstop barrage when I was up there for it. But then they let me talk uninterrupted for the rebuttal, so I was able to drive home my themes for it. It was also this funny thing too, where the attorney for the city, in addition to making the big concession, his time was expiring, and he was trying to rush and get in a bunch of points, and then. And at this time, Justice Rehnquist was very much a stickler for time, and so he said, "In your honors, I'd like to leave you with just 4 points. Red light." And he said, "Well, I guess I'm not going to be able to tell you what those are. Thank you." And so the court then
if you knew them, if you only knew them.
They had actually asked me, do you know what those words were? And, I should have said, I joked afterwards that it should have been, we can take everything, would have been the words that was kind of the theme of their argument. And so that provided a little bit of a light moment amidst the proceedings. Then he got to be able to tell on the steps of the Supreme Court afterwards.
And Wesley, that kind of brings me to this thought about knowing how to walk that line between, being very professional and very serious, but at the same time realizing that the justices over there, they're human, they're actually talking to each other. They also appreciate a good joke, like Justice Scalia, famously got so many laughs from the audience. So when you're up there and maybe there is an opportunity for sort of a moment of lightness, do you take advantage of that, or do you just kind of stick with a very serious script that you have?
Well, I think it's very important for advocates to go and see the court in operation before they argue. And I did that a few times. I'd actually never been to an argument before. And something that struck me was that for the justices and the advocates, this is like any other courtroom. Folks have a job to do. One thing that I've tried to stop doing and kind of can't is holding up my pen as I'm arguing and sometimes even clicking it. And I was reassured to see that advocates at the Supreme Court are doing that too, because, they're working. It's not a performance. It's a legal argument. And I have tried, and I think successfully did this at the Supreme Court, to think of the argument not just as a conversation, but as a conversation among peers. It can be challenging at the Supreme Court to think of yourself as being on the same level. But the bottom line is no one in that room knows more about that case than you. At least that's how prepared you should be. And, viewing the situation as one in which you are on the same level as the justices and trying to help them do their jobs to get to the opinion that they should reach, that you're convinced is the correct outcome, does require a conversational tone, does require you to be relaxed enough to laugh at a joke when one comes up. Justice Breyer was being self-deprecating and saying, I have a hazy recollection. Often these are wrong. And, you can hear me on the recording just kind of cackling as I leaned back. So, I think that, you have to rely on your instinct to make sure that you walk that line well. But you're probably more in danger of being stiff and overly formal if you don't have that sense of sort of, God damn it, I know the right outcome here, and I will ensure that you at least hear my perspective on this.
Yes, Bill.
I got regarding humor at the court, I got a very good piece of advice that I'm a person who has a tendency to crack little jokes and make little, I think, are witty asides.
No.
We don't get those emails, Bill.
And one of the advocates who had been up there a long time said that you shouldn't necessarily be stuffy and stiff, but do remember that you are the straight man to the Supreme Court's joker, and that they like to make jokes, and you can participate in those jokes as basically the guy who is setting up the joke. And if to really show my age, he basically said that you're the Bud Abbott to their Costello, and it was that I found that to be extremely helpful because it reminded me not to crack jokes, but to allow the conversation to go forward in a way that allowed some levity. But didn't necessarily originate from me.
Well, I was just going to say one of my favorite moments of Bill's argument is a human moment where you can hear his charming guffaw at a joke that one of the justices was making. And it just struck me that, he's in the zone, he's comfortable.
Yeah, that's very important. And speaking of Bill's argument, so Justice Ginsburg was, as she often is, the first person to ask a question, the first justice, and a very pointed, challenging question, right? She talked about Arizona trebling the amount. And how did you deal with that question, and what was she driving at?
So her question, and this is consistent with her reputation as being she's not a very aggressive questioner, but when she does ask questions, she is very much goes to, especially when she's not on your side, she goes to what she sees as the weakest point in your argument and asks you to specifically address it. And a less prepared advocate would be in danger of conceding something, basically saying something that would undercut their argument with the other members of the court. And for us, the argument, the biggest challenge was the idea that the U.S. Supreme Court had already held that the government could fund political campaigns without violating the U.S. Constitution, and so we were sort of arguing that they can do that, but they can do that in a way that's not that doesn't disincentivize people who are not getting that funding from speaking. And so what Justice Ginsburg asked was, well, Arizona could give your opponent a ton of money, way more than they would get under the clean election system, and that wouldn't be unconstitutional. So why is it if they give you, under this system, if they give your opponent significantly less money, why is that unconstitutional? And it's a very, very good question, but one that we had prepared for. And it was precisely, Scott was talking about earlier about the theme, and it allowed me to actually draw to our theme, which is that what's wrong here is not the provision of funds to publicly financed candidates. It's the trigger of what gives that money to the publicly financed candidate. And because that trigger is something that the speaker, the privately financed candidate's speech triggers, that creates the disincentive to speak. That's not present in those circumstances where the government simply gives a lump sum to publicly financed candidates.
Mr. Maurer, you don't have any objection, you wouldn't have any objection if Arizona trebled the amount at the outset. In other words, there was a maximum amount, the so-called matching funds. If it were given all in one lump and the publicly funded candidate was told, give it back if you don't use it, that would be okay?
That would be constitutional under Davis, Your Honor. This case is not about whether the state of Arizona may provide campaign financing using public funds, nor is it about whether the ability of Arizona to ensure that those who receive the public funds can run effective campaigns. What this case is about is whether the government can turn my act of speaking into the vehicle by which my political opponents benefit with direct government subsidies. So it was a challenging question. It was the most, I think, logical and sort of straightforward attack on our argument. And it was, but I believe we were able to use it as a way to actually undermine that argument and really draw the court to the real issue, the theme, which was it's the trigger. You can't have a trigger that disincentivizes me from speaking.
So in a way, it was an opportunity, right? This is her first question, and it actually allows you to continue with your theme and to set the record straight.
Yes. And you're always drawing, there's always a balancing act when you're getting questions from justices that you anticipate are going to be hostile to your position. You want to answer their question and you want to be respectful. At the same time, you want to make sure that you're able to communicate not just the answer, but why you're correct and why you should win, continue to win in light of that, later on in the argument, for instance, one of the big issues in the case was the court had held repeatedly that leveling the playing field was an illegitimate reason for regulating political speech, that the government shouldn't be acting basically as a sound engineer, making sure that some people's voices got raised and some people's voices got lowered, and in ensuring that people, basically sitting there fiddling with the knobs in a way that interfered with people's free speech. And Justice Kagan asked me, isn't the purpose of this law was to fight corruption, and that's how they had to sort of categorize it because it wouldn't be constitutional otherwise. And luckily, I had a quote from the head of the government agency that handed out this money, saying that it cannot be disputed that the purpose of this law is leveling the playing field. So she asked me that, and I said, I respectfully disagree, Justice Kagan. In fact, I have this quote from the head of the organization that hands out the money, saying not only that that the purpose is leveling the playing field, but it can't be disputed that the purpose is leveling the playing field.
I think the purpose of this law is to prevent corruption. That's what the purpose of all public financing systems are.
Your Honor, I would respectfully disagree that the purpose of this law is to prevent corruption, and I would like to read from the executive director of the Clean Elections Commission, who said that it cannot be disputed that the purpose of the Clean Elections Act is to equalize the playing field and to give participating candidates equal opportunity to get their message out, which is at Joint Appendix 236.
And so I think that was, if you didn't have the level of preparation that we have and hadn't thought strategically about the questions that we were going to get, that would have been a missed opportunity. And as it turned out, that question was, I think, extremely effective in shoring up the justices who were on our side that this was an illegitimate purpose behind this law.
Speaking of Justice Kagan and leveling the playing field, Dick, she had a question in your case, Espinoza, about discrimination, right, and harm. She kept asking you about, there is no discrimination. What is the harm there?
And the consequence of this decision is that there is no discrimination, that neither set of parents is getting what they want. Now, you might say, both should get what they want. And maybe that would be a better world. Maybe. But the constitutional harm that it seems that you have to allege here is the discrimination. And there is no discrimination.
Your Honor, there is no discrimination because the Montana constitutional provision requires discrimination on its face and as applied to our clients.
So, how did you deal with that question? What was she driving at there? And did you also see it as an opportunity to drive the theme of your case home?
Definitely, but to put the question in context, you have to understand that the argument of the briefs from our opponents was very peculiar. They didn't really try and defend the decision below on the merits of the decision below, because the Montana Supreme Court had basically said there's no problem under our Constitution or the federal Constitution with discriminating against families that want to choose religious schools as opposed to secular schools. But because there was no severability provision in the legislation, they decided that what they had to do, after they said that the inclusion of the religious schools violated the state constitution, they then basically invalidated the whole program. And so she was saying, because the program is invalidated, there's no discrimination against people who want religious schools versus non-religious schools, because that was what the other side had argued in their Supreme Court papers. It was a very disingenuous sort of argument because they had basically conceded that the underlying reason that the Montana Supreme Court had acted was that it's perfectly okay to discriminate against religious families and the choice of religious schools. And so we were trying, both throughout our briefing in response to that and in the oral argument, to say, no, wait a minute. What they're not doing here is leveling down as opposed to leveling up. What they're doing here is acting because they think it's okay to discriminate against religion. It's just, irrelevant that they invalidated the whole program. There's no doubt, and the other side has conceded, which we had right there in our opening, they have conceded that to exclude religious schools from a religiously neutral program would in fact violate the Free Exercise Clause. And so that was what we wanted to get them back to.
And speaking of opponents' briefs, Wesley, in your case, Tim's, your opponents also took kind of an unusual position, right? At least a position that wouldn't be expected at the first glance. How did they try to frame the argument, and what did you do to respond to that, to frame their argument?
Sure. Similar to Espinoza that Dick was talking about, they kind of assumed that we were right on the question presented, that the Eighth Amendment's excessive fines clause applied to the states, and instead advanced, I thought, this rather clever argument that regardless of whether the excessive fines clause applies to the states generally, it does not apply to state civil forfeiture actions. And the argument being that, correctly pointing out that there were many cases of civil forfeiture actions that were manifestly excessive, where no one had raised the excessive fines clause. I think that was the best they could do with a dog of a case. And, it was challenging for us to address because it wasn't the issue that the court had granted cert to decide. And so we've been talking about themes. I mean, our theme was we're here to decide if the excessive fines clause applies to the states, not to decide issues that the other side has introduced into the case that never existed before. And ultimately, our work on that issue, I think, was very influential on the court. Justice Ginsburg was asking in our argument about incorporation of the Sixth Amendment's jury unanimity guarantee, while a case, Ramos versus Louisiana, was pending, asking whether that guarantee applies to the states. And Ramos was heard this term, and the argument of the state of Louisiana was similar, that, regardless of whether jury unanimity is required under the Sixth Amendment, it applies differently to the states than it does to the federal government. And after Timms, and relying on Timms and Ramos, the court was very clear that there's no daylight, they said, between the scope of a federal constitutional right as it applies in federal court and the scope of that right as it applies in state court, overruling a case from the 70s called Apodaca versus Oregon. And so, the government's argument was an opportunity for us to focus the court on our thematics. And in our case, I think we set them up to reach the correct result in Ramos as well, effectively closing the book on incorporation of the Bill of Rights.
Yes. Let's talk a little bit about Justice Alito. Was he not clear what constitutional provision you brought your argument under?
Oh, no, I don't think he wasn't clear on that for a moment.
I'm joking. Yes. What was going on there?
Well, as some listeners may know, Justice Thomas does not effectively believe in the concept of substantive due process. And because the court's incorporation cases are built on the idea of substantive due process under the 14th Amendment. He has, in other incorporation cases, refused to join the opinion incorporating the case and instead has joined the court in its judgment, basing the application of a federal constitutional right to the states not on the Due Process Clause, but on Section 1's Privileges or Immunities Clause. And we knew from the decision in McDonald versus City of Chicago that Justice Alito and Justice Thomas agreed on the outcome of these incorporation cases, but did not agree on the constitutional provision on which they relied. And so we very consciously made the privileges or immunities argument in order to get Justice Thomas's vote. You're just not going to get it if you don't, in part, base your argument on that. So what Justice Alito was asking me was, what's the precise provision of the Constitution that you rely on? And I said, about to say Due Process Clause, and stopped myself and kind of realized the trap that was being laid for me and said Section 1 of the 14th Amendment, Your Honor. So he says, it's part of the substantive protections that you get for due process, right? I said, yes, Your Honor. We also have an alternative argument under the Privileges or Immunities Clause that I'm not here to concede.
Well, what is the provision in the Constitution that you rely on?
The Section 1 of the 14th Amendment, Your Honor.
It's a component of the liberty that's substantively protected by the Fourth Amendment's Due Process Clause.
Yes, Your Honor. And we also have an alternative argument under Section 1's Privileges or Immunities Clause.
So that's a sort of unspoken dynamic that's going on. Bill alluded to that. The conversation between the justices and the advocate, I think, is often more nuanced than what the audience might recognize.
Let's move to this phase of the case when the oral argument is over, you're waiting, and now the decision comes down. Scott, in your case, what was it like to hear the decision, and what did you do next?
It was one of those instances where we kind of knew it was getting close to the end of the term. We were expecting a decision really any day. We were refreshing the websites that were tracking it. And then again, though, the court calls you to let you know a little bit before they release it publicly. And so the call was put through to me, and they say it in a way that's very legalistic. I was just calling to let you know that the court today affirmed the decision in Kelo. And I knew what that had meant. We had lost by one vote at the Connecticut Supreme Court, and then we quickly found out that we had lost by one vote at the U.S. Supreme Court. And so it was incredibly disappointing to hear that. And not only was I disappointed for the effects this would have potentially on the country, but also for our clients as well. And having to call them and tell them that, and is one of the most joyous things you can do as a lawyer is to call your clients in a public interest case and tell them that you won. And of course, the most disappointing and devastating thing is to let them know that that we had lost the case. But and it was something that the clients in this case had fought for so hard, and it all stuck together, and really were really incredible people to represent. But we knew that we were not going to just take this and say, well, the court issued its decision. I guess that's it. We'll look for another issue to litigate. The whole reason why you have a public interest law group is that you don't just argue cases in court. You use all the tools of public interest law to raise awareness of these issues, and that's what we were able to do in the context of eminent domain abuse. And so we had hoped that this backlash was going to happen. We had laid the groundwork to effectively make sure that it happened. And as soon as the court's opinion was handed down, we did just that. We marshaled resources here at IJ. We put together a campaign called Hands Off My Home that was going to capitalize on what really happened in the wake of Kelo, which was this genuine backlash against the decision. And you saw this manifested in all kinds of different ways. I remember after the decision was handed down, the day after, I was walking along the street in D.C., and I heard people talking about it and saying, can you believe what the court had done? Jay Leno had Arnold Schwarzenegger on that evening, and he was saying, can you believe this happened? He goes, it's unbelievable, Jay, that the Supreme Court so it was just one of these kind of cultural moments that, rose up where people were just astonished that the court had decided the case the way it did. And so we knew it was a special moment to kind of capture this national mood. And so we, for the next several years, put together a program to fight back against this in state courts, which we did, and got a lot of opinions that rejected Kelo under the state constitution. And then 44 states have passed legislation that have somehow, in some ways, better protected property owners. And in half of those states, they're actually better protected than what they would have been even in a favorable outcome in Kelo. So it was kind of one of those classic examples of losing the battle but winning the overall war. But it doesn't make it any easier to deal with the fact that the court got the Constitution horribly wrong. And it also, meant that Suzette and her neighbors had to leave this neighborhood that they were so devoted to. But, they know that their fight was not in vain, and that out of this very bad Supreme Court decision, we got a lot of positive changes in the law to better protect home and small business owners throughout the country.
Yeah, to the point that your opposing counsel actually, just a couple of years ago, he wrote an article and the headline said, why Kelo is not Dred Scott, right? And that's just like, if you actually have to talk about Dred Scott when you talk about Kelo, you're in trouble.
That's right. That is, and I've heard this at various conferences and things, that the supporters of eminent domain abuse and eminent domain for private development thinks this is the worst outcome that could have happened to them, and they recognize that, and they know how wildly unpopular this power has become. But our ultimate goal, of course, is to get this constitutional mistake corrected, and we'd love to get this issue back before the Supreme Court and have them overturn this. Justice Scalia would routinely say in public addresses that he was convinced that when it asked him, what was the decision most likely to be overturned, he invariably answered with Kelo.
And Wesley, in your case, Tyson got a unanimous victory, but that his ordeal was far from over, right?
Yeah, it's honestly still far from over. We got a unanimous decision from the U.S. Supreme Court that the excessive fines clause applied to the states, but we're remanded to the Indiana Supreme Court to decide how you decide whether a forfeiture is excessive and therefore unconstitutional. So Sam and I litigated before that court again. I think we've been there 3 times now. And they ultimately adopted the test that we advocated. Essentially, you got to look at all of the circumstances and decide in equity whether or not a given forfeiture is excessive. They didn't resolve the case. They remanded it back to the trial court in rural Grant County, Indiana, where earlier this year we had a mini trial on those factors that the Indiana Supreme Court had laid out. And the trial court recently again ruled in Tyson's favor, holding that the forfeiture was excessive and ordering the state to return his car. The state is now appealing that decision to the Indiana Supreme Court, and they've indicated that if they don't get a favorable decision there, that they intend to petition the U.S. Supreme Court for cert. So fortunately, in the course of all of that, Tyson has gotten his car back. The state agreed, I think kind of seeing the writing on the wall that it was high time after 6+ years to return the vehicle to him. So he's got it. He just got it this week. And we will continue to defend his right to keep his property. I don't think they stand much of a chance of getting a reversal at the Indiana Supreme Court, and virtually no chance of the Supreme Court revisiting this at this stage. So we anticipate ultimately that our victory will stand.
More importantly, Bill, how's your finger?
Finger's doing well. It appears to have come out of the whole trauma without any lasting damage. But there's a scar there to always remind me of the good times.
But so you won, right? How did you feel? How did your clients feel?
The clients were obviously delighted. The interesting thing about how I found out that we had won was that you don't know when the case is going to come down, and our case ended up being the last opinion issued on the last day of the term. So I was actually on a long planned vacation with my family, and we were it was sort of a multi-layer vacation. The first part of it was we were visiting my parents in New York, and the case hadn't come down at that point yet. And my parents were very old school. They didn't have Wi-Fi or an internet connection of any kind. So when I realized
it's 2011, it's not 1988.
My parents had a rotary phone until they were forced to get rid of it, and they just were not the type to really embrace new technology. And so I actually had to go over to one of their neighbors and asked if it would be okay if I hopped onto their Wi-Fi signal that day, so I could tell whether we won the U.S. Supreme Court case or not. And so I was hitting refresh. All the cases come out. Ours is the last one, and it comes out that that we've won. And it wasn't all that surprising because I had, reading the tea leaves from the oral argument, I was pretty confident that we were going to win. But it was nice. It was very, very gratifying to, after all that work, after all that effort, to actually get the opinion. And it was written by Chief Justice Roberts. It said exactly what we wanted it to say. One of the things that we tried very hard to do was that we wanted a very good 5-4 decision instead of a wishy-washy 6-3 decision. So we didn't concede really anything. We went and asked for as much as we could get, and that's exactly what the court gave us. And so it was a very exciting day. I was very happy to be able to share it with my parents, both of whom have since been or deceased. But it was kind of an interesting day where I was doing interviews with the New York Times and the Wall Street Journal from my dad's study. It was a very nice sort of way to end the whole thing, and it was. And in terms of the sort of the meaning of the case, our case, I think, was less about stopping something that was a significant problem across the country already, and more about stopping the expansion of these kinds of programs across the country. Because I think if we had lost this case, this would have been the model for campaign finance regulations for years to come. And essentially, the government would get into the business of being a sound engineer, and that they would decide, and being the government, they would often decide that the people who were speaking too much, whose voices were too loud, or who had undue influence, were the people who were opposing those in power. And so I think what we did in this decision was put a stop to a growing trend and a growing effort to use this kind of speech regulation to basically shut people up that the government doesn't like.
All right. Before we go, I have a couple more questions to ask about oral arguments in general. Some of them are from our Dave Kennedy Fellows. And if you guys wonder who Dave Kennedy fellows are. Just Google IJ, Dave Kennedy Fellows, and consider applying to be one of them. So, Dick, let's start with you. You essentially were the first orator at IJ, essentially, who was subjected to the 2-minute rule, right?
Yes.
Essentially, tell me what the 2-minute rule is, and do you like it, do you not like it?
I don't think of it as being subjected to it. I think of it as being benefited by it, because the 2-minute rule means that, in my case, I had 20 minutes to argue. For the first 2 minutes, you get to say what you want to say and summarize your key points, and nobody gets to interrupt you with questions.
That's good to hear, because the other 3 advocates, you guys, essentially, you had questions barely into your themes, right? Scott?
Correct. Oh, yeah, I got out the 2 sentences. I got out 3 sentences, got the theme out, and then it was nonstop response to questions. And that's true of most arguments. They are ready to go, and it is you just got to you got to be in that zone and respond as quickly as you can.
I actually went through a lot of transcripts and figured out that 2 to 3 sentences of about 90 seconds where it was about the average for an advocate at the U.S. Supreme Court to get out before they started getting questions. So I prepared 3 sentences and then sort of stopped, expecting the questions to start, and that's exactly what they did.
I'm not a big fan of it because the court can always restrain itself without it being a formal rule. And, I've had my chance to give them the thematics and my set piece argument in the briefs. What I want to do at argument is hear the justices' concerns, and I just as soon start with that.
And the good thing, you can waive the 2-minute rule, right? So,
right.
Yep. And okay, one last question before we go, and that is about telephonic arguments. I'm sure you guys all heard the 10 arguments that were held over the phone. So if you were to be preparing for an oral argument next term and you weren't actually quite sure which format the argument would take, how would you go about preparing? And also, do you think the telephonic format created more opportunities for advocates or for the justices, or maybe it's not as good as the format where you get to see them face to face? Who wants to take that one?
I think
Bill.
I think the telephonic argument just sounds like I don't think I would enjoy it at all. One of the things that is actually surprising about the U.S. Supreme Court and arguing there is just how close you are to the justices. I've never seen a bench that close to the advocates. You're practically just a few feet away from them. And so it is a very intimate discussion. And frankly, when you're looking at a justice and answering their question, you really can't see a whole lot of other justices in your eyesight. So I would find the telephonic arguments, I think, to be far more difficult and far more uncomfortable than actually arguing in front of the court itself. But that is largely because of just how close you are. You can't see the rest of the room. You can't see what's behind you. You can't see what's on the side of you. You're just looking at whatever justice you're talking to.
And Wesley, you mentioned how Justice Breyer was asking you questions and you weren't quite sure where he was going. And then Justice Ginsburg kind of explaining where he was going and kind of saving you, right? You think something like that seems like it would be lost if the arguments, given the current format of the telephonic arguments?
I think it would be. I don't think the preparation would be any different, except for perhaps, doing moots over the phone as well as in person, just to have some sense of it. I do think the argument would be different, as you're alluding to, because they're going in the seriatim questioning process from senior justice to junior justice, and that doesn't allow for the kind of conversational give and take that makes things more human. And I think it would be challenging, but if the court asked me to stand on my head and make an argument that way, I would still do it. You're there to make your case, and whatever the terms and conditions of having that opportunity would be, I think you've got to take it.
Just like with music, I prefer it live.
And that's a good note to end on. Thank you, Scott. Thank you, Dick. Thank you, Wesley. Thank you, Bill. It was great fun.